and we'll be setting up more into the in the prairies pretty soon as well. And hopefully we're going to be getting some out east as well shortly. And we'll let everybody know when those are going to happen out in the Ontario area. The issue of laying criminal charges is something that it piques a lot of people's curiosity, because the amount of power that it puts in your hands to hold people accountable that you would not otherwise be able to do, can really be very powerful. I started to learn about this way back in the mid to late 1990s when I was in Winnipeg. And at that time I was introduced to two former CRA officials. One was an auditor and one was in tax interpretations. And they were fairly high up at then Revenue Canada. And they had uncovered a multi-billion-dollar fraud involving not only CRA, but a corporation with the Bronfmans and some of the government officials in Canada as well. And I'm not going to get into the details tonight of it, but it was a multi-billion-dollar fraud. And they went and reported it, and nothing happened. So they went and decided to lay criminal charges against the people involved. And that's when they discovered in Manitoba of a corruption and cover-up that was happening in the process. And they told me what was going on, so I went and I started to make my own inquiries at the courthouse. And what my friends had found out, and I ended up confirming, was that there was a secret process that court officials were using that was not authorized by law to cover up offenses against police officers and government officials. And it was as a result of my work uncovering this with them and exposing it to a lot of people that we got this process exposed publicly, and eventually it was thrown out. And subsequent to that, we went on tour around 2000, 2001 at that time, and we were showing people at that time how to lay criminal charges as well. And what had happened is Parliament came around in 2002, and in Bill C-15A, they snuck in amendments to the criminal code to change the process for the first time in Canadian history of how criminal charges were laid. And I'll mention that briefly tonight, but we're going to go into a lot more detail on that when we do our seminars. And that process doesn't really stop you from laying charges. In fact, it doesn't at all. It does, however, make you need to be aware that what they've done to try and cover a few things up. They're not too concerned if you're charging John Doe with an offense. Their concern is if you're charging government officials. And what was happening after we laid the charge, or we went on tour, is that people started charging government officials all over Canada. And what really caused them a lot of problems is that they would never know that somebody's been charged until after a summons or warrant was issued. And this kind of leads into the comment that our supporters have said tonight, that your complaint is their restraint. And I really enjoy that comment, because government officials really believe they are immune, and you can't do nothing to them. And if anybody has seen the movie Wall Street, when the guy is sitting in his office amongst all his other people that they're into the, I forget the name of it now, but they're into the bidding and rigging on investments and so on. And he gets hauled out of there in front of all his friends. And they're all watching as the police haul him off in front of everybody, all his superiors, all his associates and co-workers. And it really amounts to the same thing when you charge government officials, and they're sitting in their office and some sheriff or some police officer walks in and hands the guy a summons or arrests him on a warrant. All his bosses, all his superiors, all his co-workers, everybody's looking and saying, hey, what did you do? And it scares the hell out of these people. And it really is empowering to know these people who previously thought they were immune, their life just flashes before their eyes. They just start thinking their job is gone, all their security of tenure is gone, all the comfortability they had is gone, and suddenly they're worried, I'm going to jail. And they really, really have a lot of fear imposed into these people right off the bat. And it sends a message, not only to them, but to everybody in the office, that they shouldn't be doing what they're doing. And it stops them from committing criminal offenses in the future. The information that we are going to share with people at our seminar is some of the best information in Canada. Our book, called The Criminal Charging Procedure in Canada, right now stands as the only annotated book in Canada, including in the legal community, as to how criminal charges are laid, how the process works, all the supporting authorities to back it up, and we include in there many of the forms that, in fact, all the forms that you're going to need, no matter what province that you happen to live in. And the information comes from well over probably 14 or 15 years of experience that I have had dealing with various courthouses across Canada on this matter. I've helped several people in the past, especially when court officials refused to accept criminal charges. We had a court official here in British Columbia refuse to accept criminal charges for a friend of mine, and I went down and gave her heck at the counter, and she still wouldn't take them. And then we got a call the following day because she, out of fear, called the chief judge at home that evening. And the chief judge told her in no uncertain terms, you take that charge because you're required by law to do it. So we were called and we went back the following day and the charges were accepted. That has happened several times, not only here in BC, excuse me, but also in places like Manitoba, Alberta, Ontario, where we have helped people get through that hurdle, where the government officials simply don't want to. Okay, thank you. Where government officials try to not take your charges if you are charging the police or other government, for example. And we've helped a lot of people get through that initial hurdle, and we've been very successful at it. The picture that you see on the screen that you've got of Joe Flaherty with the handcuffs on, that was done for a reason. One of the major things that we have tried to talk about for a long time is why is there so much criminal activity? And essentially criminal activity, for the most part, goes back to the fact that people are broke. They have no money, they get impoverished, they lose hope for the future, and nothing matters. So they get into a life of crime. Whether it's white-collar crime or on the street, it doesn't really matter. And the primary source of that is the usury-based money system. It focuses all the wealth in the hands of a few people, less than 1% of the people, primarily bankers, politicians, and so on. So everybody else is left with less and less money, and more people start going into crime. Those 1% of the people are the ones that should be charged, and the police will not do it. And our goal is to start charging these people for what they're doing. Usury is a violation of our law. It has been since the beginning of time, and it's only been the last 250 years or so that it has been snuck into our system. And you can see the results all over the country, and every country that allows it. So we want to empower people to start charging government officials to make sure that they know that they are not immune from any criminal activity that they do, that people across Canada can lay charges against them. If you are in British Columbia or if you're in the Maritimes and you know that a criminal offense has taken place in Ottawa, you can still lay charges against them. It may cost you a little bit of money to get to Ontario, but if you can show that the offense still took place anywhere in your vicinity, you can charge them. In other words, what I'm saying is you don't need to be a direct victim of a crime in order for you to go and lay a criminal offense against somebody. And that's important because a lot of people really do believe that if you're not the victim, you cannot go and lay a charge. And that is simply not true. The slides that we're going to show you, you'll find in the bottom left-hand corner that we're going to go through right now are all numbered. So you can reference them if need be later on during questions at the end as well. If you have any questions, you can reference the specific slides. But those are our objectives as we go through them tonight, and I give an overview of what our seminar is going to be, that we want to empower people. And I hope after our tours are done, and if you get a copy of our book and decide to do it, or if you've been wronged by the government, we hope that we can renew people's interest in laying charges against government officials so that they know they are not immune from their criminal activity. These are some of the topics that we go through on slide 2 for our presentation. And I'm going to go through just an overview of each one of these this evening. And then when we're done at the end, after number 8, we'll take a few questions. There's not 211 slides, of course, in this presentation. That is going to be for our seminar, which is about 3 hours. But this will give you an overview of what we're going to talk about tonight. And I'll go through each one of those briefly to give you an idea of how they relate to the process for laying criminal charges. The first thing that we're going to talk about at our seminar is the nature of the criminal law in Canada. And the criminal law is significantly different than provincial statutes or provincial regulatory law, for example. And if you're going to lay a criminal charge against somebody, you need to know what the criminal law is. Where is the criminal law located? Who makes the criminal law? And basically, the criminal law is made by Parliament. They are the ones that were given jurisdiction under Section 91 of the British North America Act, now renamed the Constitution Act of 1867. And I should pause to point out that it's interesting. Recently, there's been an article in the newspaper that Bora Laskin, who is the chief judge, I believe, of the Supreme Court of Canada, they have now been found to have, when the patriation reference case came in on the charter and so on in 1982, the Supreme Court of Canada has been caught improperly, I would say illegally, unlawfully, talking to politicians behind the scenes about what their decision was going to be. Think of the implications on that, because they're trying to say that's your constitution now, and here are your chief justices or justice and other judges from the Supreme Court of Canada indirectly behind the scenes talking through other people to Trudeau, who was the prime minister at the time, and others as to how they were going to rule on the decision. So much for the independence of the judiciary, right? I suspect, in fact, I go so far as to state unequivocally, if people could get information to back that up, those people could be charged if they're still alive today, whether they're chief judges of the Supreme Court of Canada or anybody else. So we're going to talk about at our seminar the fundamentals of our criminal law. What exactly is it? Who makes it? How it comes to be? And where is it located? Criminal law is not just in the Criminal Code of Canada. You have drug legislation and various other federal offenses that have, or federal acts, that have offenses in there that specifically state if you commit an offense against it, it's an offense, and then the criminal code provisions would apply to it. And we briefly compare that to criminal law and how it works in other countries as well, because our common law system is significantly different than, say, Europe and how in other countries would go to do it, and indeed previously Quebec as well, but they're under our federal law, so they also follow the same criminal procedures now too. So those fundamentals are going to be important when you go to lay a charge, to know exactly what it is you're going to be charging and what the principles of it are. And essentially, I guess to make it very, very fundamental, a criminal law is an offense not just against the victim, but a criminal offense is an offense against everybody in society. And it has been viewed that way since the beginning of time in our law. The second chapter we're going to talk about is basically the methods that are involved are bringing offenders to justice if you know somebody has committed an offense. I guess most historic that has always been there has been vengeance. And we're going to go into some detail talking about the pros and cons of using violence or vengeance, or retribution, to go after somebody that you know or believe has committed a criminal offense. I want to emphasize there is a place for everything. However, violence really is a last resort when everything else fails. And if you're living in a small community way out in the woods and the police are refusing to do anything against the perpetrators of crimes that you're suffering from on a regular basis, you know what? It may come down to somebody taking somebody out in the back lane and giving them a few shots. But that is when everything else fails. And it's important that we don't recommend violence. We recommend some way of charging them in a legal process and using that as much as possible before anything else, anybody resorts to violence or anything else. But that has always been here, and we're going to go through some details at our seminar talking about that and what the pros and cons of it are. Then we're going to spend most of the time talking about the legal processes that are available, both historically and to the present. And you know, if you think historically, there didn't have the legal system going back 500, 600, 700 years ago that is in place today. And when somebody committed a crime and they found out about it, they would let out the hue and cry, and then everybody would come around and they would try to grab the offender and find him. And that has progressed to date as people going down to the courthouse and laying criminal charges and are putting them under arrest. Interestingly, with the citizen's arrest process, that law, which has remained the same for basically centuries, has been changed in the last, I believe, 5-6 years as a result to a store owner in Ontario. And somebody robbed the store and he took after them and put them under arrest, far removed from where the actual offense took place. And he was charged, the store owner. And when it went to court, the judge basically interpreted the law of citizen's arrest to say that you don't actually have to arrest somebody right where the offense took place. And as long as it's in the process, for example, if you're chasing him, you can now put him under citizen's arrest as well. So it's been a broadening of the citizen's arrest process that's in the criminal code, which is a good sign, a very, very good sign. You don't actually have to be right there and grab somebody when he's, say, assaulting somebody. If you see him assaulting and he runs away, you can go and grab him and run after him and put him under arrest now, whereas before you could not. And that's important. That really broadens the ability to for people to hold offenders accountable. And the subject we're going to talk most about today, of course, is the laying of criminal charges. And that's the subject of our seminar that we're going to talk about. And we're going to go through the entire process of how you can lay a criminal charge, how you word the charges. Every aspect of it is going to be analyzed so that when you leave the seminar, you will leave being empowered, not only if any government official breaks the law that you can charge them, but anybody. If you are a victim of an offense, or if you know if somebody has committed an offense and the police don't want to do anything, you will leave knowing that you can go out and you can lay the criminal charges. And the ability to lay criminal charges is important. And this court case came out of Alberta several years ago, and it recognized that the Law Reform Commission of Canada had agreed that your ability to lay private prosecutions was necessary to hold government officials accountable. It's a common law right that goes back hundreds and hundreds of years. And the courts have upheld that your right to lay criminal charges is the most fundamental basics of our criminal law. They will not be taking it away anytime soon. And we're going to go through some of the options if you witness a criminal offense. Not tonight, of course, but at the seminar. We're going to go through all of these options and explain the pros and cons of them. What will happen if you see a criminal offense or if you know of an offense and decide to do nothing about it, especially by government officials? What happens if you want to mediate, or if you report it to the police? If you want to sue them, arrest them, lay your own charge, or vengeance. We're going to spend several slides going through each of these so that you get an understanding and an idea of what the benefits are to laying your own criminal charges as opposed to any of the other options that may be out there. After that, we get into the fun stuff, and we start by describing what the difference is between an indictable and summary conviction offense is going to be. We'll be talking about the forms that you're going to use, because each one will require a different type of form to use. And we're going to give you some idea as to the majority of differences between these two different processes. One of them that people should know about right off the bat is that in an indictable offense, if you're charged, you're the accused. In a summary conviction offense, the person charged is not the accused. They are the defendant. And many people confuse them and just say everybody's the accused. However, the criminal code defines them differently. And we're going to go through that as well. So we'll go through the nature of the process on how to fill out these forms, what forms to use, and the nature of the charges and the details that you have to put on each form. When you go to lay a charge of assault, how does it have to be worded? And we'll show you some examples of the forms that are going to be used as well, and the purposes of bringing people to court by this method. And then we get into section 504 of the code. This is the first section I learned about 15, 18 years ago, and is the section that codifies the common law principle, or your right to lay a criminal charge against somebody. This is the beginning of the process. And the courts have struggled, I wouldn't say struggled, but the courts have really differentiated between the process and the actual substance of charges. Let me give you an example. I was in a courthouse one day, and this was when they first laid a charge against me of failing to file back in 2003. And I was also dealing with a driving matter at the time. And I dealt with the driving matter in court, walked out of court, and was walking and was halfway out of the courthouse in Kelowna, BC, when 6 sheriffs physically stopped me and brought me back to the courtroom, because unbeknownst to me, the trial coordinator had tipped off the Crown that I was in court on the driving matter behind my back, and the Crown then brought forth the income tax charge into the same courtroom, and I had left the court before he was able to get it out, so they physically got me. On appeal, the Supreme Court of BC held that I was correct. The sheriffs had no force, no right to bring me back into court, and it was an assault. And they upheld, however, that once you're in the courtroom, they have jurisdiction over you, and it doesn't matter how they get you there. And the judge went on to describe at that point that, from his perspective, the process in getting you there didn't really matter as much as the fact that you were there. However, many authorities disagree with him, and I point out that I disagree with him. The process, if nobody's above the law, then the process of getting you there must comply with the law as well. And a lot of the criminal law that you deal with in the criminal code deals with procedures on how to get you into court, how you get released if you've been charged, the whole trial process, preliminary inquiries, trials, juries, and so on. All of that is procedural information that is contained within the criminal code. And they use that to apply to offenses under other statutes as well. So the process is important. In fact, in many cases, it's critical on how they get you into court. And we're going to talk about that process at the hearing as well. And specifically, some of the information we're going to talk about when you go to lay your criminal charge. We're going to go through the process, as I said earlier, and how to fill out the forms. Who decides what charges to lay? and we'll talk about who's going to make that decision, how you're going to complete the form, and how you're going to word the charges on it, the details that need to be on the charge. We'll discuss who can lay criminal charges, what criteria has to exist, the most obvious being that you have to have reasonable and probable grounds to believe an offense has been committed, what knowledge you have to have of the charge the offense taking place, what the court registry staff, their duties are. When you walk in the door and you tell the court clerk, here's my criminal charge, what are their duties? Where the accused has to, yep, okay, sorry, it's not the greatest mic, I apologize. We'll talk as well about where the accused must live and where the offense has to have occurred. For example, if you're in Alberta, can you lay a charge in Calgary for somebody who's committed an offense in Winnipeg? What happens if the JP refuses to take your charge? As I said a little earlier on at the beginning, that has happened in the past, and we've been very successful at forcing them to take those charges. And how many charges you can lay at one time. These are some of the things we're going to discuss and go through in detail as we progress through our seminar, so that when you lay the charges, you don't want to walk up and lay the charge and have somebody tell you, sorry, they're filled out wrong, or you've done something incorrectly, and then you've got to travel an hour to get back home and redo it again, or go back another day to relay it. That can take a lot of time and be very, very aggravating. So that's going to be our goal and our objective, is to make sure you know how to fill out the forms correctly right from the beginning. Once you get there and you get the charges laid, then comes time for the process hearing. And the sole purpose of this process hearing, which has been in effect for 100 years, is to make sure that innocent people are not charged with offenses and brought into court. In other words, it's there to prevent somebody from going out and falsifying charges against you or anybody else when they don't have evidence to back it up. That's the sole purpose of it. And there's a lot of logic behind it. Falsifying a charge against somebody, even if you're eventually convicted of it, can ruin somebody's career, their life, their family's career and lives, and cause a lot of stress and a lot of problems. So the purpose of the process hearing is critical, and I'm a big supporter of it, although I'm not a big supporter of the way the courts have been acting upon it for a lot of times. So we're going to discuss what the process hearing is and its purpose, and we're going to go into some detail on that to make sure you know that it's there to protect innocent people. Right now, as I said earlier, they came up in 2002 with changes or amendments to the criminal code. There used to be one procedure for laying criminal charges, and one procedure for everybody, whether you were a police officer, a CRA official, a government official, or just a private individual. Everybody had the same procedure to follow. That got changed in 2002. And now there's two separate procedures to follow. One if you're a government official, and one if you're a private or individual. And those differences now are critical because although for the most part they're administrative, if you don't follow them, you're not going to get heard. And we're going to go into the whole nature of the process hearing and interpretation of Section 507, which says that a process will not issue unless a case for so doing has been made out. What do those words mean? Because you will not get a summons or warrant issued unless that test has been met. And we're going to show you the case law and authorities that have interpreted that over the last 30 or 40 years. And it's not a very complicated test. In fact, really the test is quite low to get a summons or warrant issued against anybody in Canada. But you have to meet that test and know what it is to make sure the judge and or the Crown does not take advantage of you. You need to know how much evidence you need to bring with you. Do you bring everything with you that you've got to court? Well, at one time it may not have mattered, but now with these separate procedures in place, it does make a difference. And we're going to show you why you should only bring part of your evidence, not all of it. We're going to go through the essential elements of this procedure and how and why it is conducted. It used to be heard before a JP, now it's a judge that hears you. And the JP gets to hear the government officials. And we're going to go through why those changes were made and the nature of those hearings that take place and why that was done that way. Most hearings only take a few minutes for government officials. But it's interesting, they force you into half a day sometimes or more in order to get process issued. These procedures are absolutely critical to knowing or to having to know so that when you get there, they don't force you to give away your hand and they don't force you to sit all day in court arguing something that you really don't need to argue when you get there. And we're going to talk about what if no hearing is held if the government officials, police, or whoever have charged you. And that's critical. For example, under 505 of the code, if you're charged and released, the officer has to lay an information prior to your first court appearance. So if you get to court and you just walk in and deal with it, they'll set up another hearing date, tell you to get a lawyer, and away you go. But if you check the file minutes before the court hearing, there's a lot of times when the police have failed to lay that information. And you can get the charges thrown out right then and there. And a lot of people have done that in the past. So these are some interesting points that we're going to go through that most people are unaware of and are absolutely critical to knowing when we talk about the procedure. The new section is 507.1, and this is what applies to you. I've already described why these changes were made, and a lot of it, I don't take pride in this, but a lot of it was made as a result of my activities in early 1900s and 1990s, late 1990s and 2000, teaching people across Canada how to lay charges. And they really, really got a good scare put into them, especially at the higher levels of government, because people were laying charges and there was nothing they could do about it. And it scared them all. So this new section was made, and we're going to talk about why these changes were made in more detail than I'm going through tonight, and how they apply to your criminal charges. When you go to lay a charge, what are the new duties that are placed upon you to go and do this? A lot of people didn't know about these changes and still don't know about these changes because they're not advertised. But if you don't comply with them, you're not going to get heard. And one of the most important aspects that you have to comply with is that now you have to give notice to the government before you will get your hearing. And we're going to talk about how and why they have to be given notice, the procedure for giving them notice, and how you prove it. When you walk into court, that you can prove that they've been given notice. We'll talk about the nature of the hearing, how the judge conducts it, what your obligations and duties are at the hearing, what your test is to be met. Every aspect of that hearing will be analyzed for you. So when you go into these hearings, you will know and be prepared to go through, hopefully, a smooth process where you go in, get your work done, and get out successfully. One aspect that's always applicable, it has been for centuries, is the Crown's ability to stay charges. So we're going to talk about that, what their powers are, what a stay of proceedings is from the Crown compared to if a judge stays proceedings, when and how the Crown can lay or stay charges. They tried that with me in Winnipeg decades ago, trying to stay charges, for example, prior to my process hearing. And I was successful in making sure that that never happened. But they have tried it across Canada, and sometimes they were continuing to do it up until these new changes were laid. And now, in the last 3 or 4 years, there's been some case law that have absolutely come out. In fact, it was 2012, have absolutely come out and ruled that the judge or the Crown prosecutors cannot stay charges anymore until you've been heard. So we've been successful in having that happen, and the courts recognize that finally. Because one of the things they were trying to do is stay the charges before you would even get your evidence on the record, so that, of course, the government officials it would just be a big cover-up. Nobody would ever know. At least now, you will always get heard, you will always get your evidence on the record, and it will be recorded. So you can get transcripts as well. We have been successful in getting a lot of changes made positively, despite the fact that Parliament has gone and tried to put other duties and obligations in front of us. And we're going to talk about some additional subversions that could take place along the way. What if the court refuses to accept your charges? What do? You're standing at the counter, and you tell the JP, here's my charge, and the JP says, well, I'm not going to take it. What do? There's a lot of reasons they could refuse to take it, and we will go through those and tell you how to respond to the JP, and we've got a lot of experience doing it successfully. We'll discuss what happens if issues of law are raised at your process hearing, if the Crown starts arguing legal issues, or if the Crown is cross-examining you on legal issues, how you can respond to them. One of the tricks they're trying to raise now is the issue of mens rea at the process hearing, and trying to say, well, yeah, you've got facts to support your charge, but you've got no evidence that the person you've accused intended it to happen. And that can be very difficult for virtually all of us, because we don't have the experience, of course, to be able to prove intent as a lawyer might have, or a Crown prosecutor. And a lot of times we might not have that information. However, again, successfully, last year, we had a court in BC agree that mens rea can be inferred from the facts that you give to them. So it's not something you need to prove directly, and we'll talk about that case that we were successful on here in British Columbia to prove that you don't need to prove that, or you don't need to provide evidence of that. The judge can simply look at the evidence you have and go, well, obviously it looks like there's an intent here. We'll talk about what you can do when there's errors on your information. How do you correct them? If you have to fill out new forms, what you can do. And whether you have a right of appeal. If you go to your process hearing and the judge says, I'm not going to issue a summons or warrant, what options are available to you? You can relay charges. At one time before 2002, you can relay them no matter what, even on the same evidence you had originally. You could walk down the next day and relay the charges. That's been altered a little bit. And we're going to talk about what criteria have to be met if you don't get a summons or warrant issued right away, how you can go back down and give it a second shot or a third shot to try and get these criminals brought into justice. So as you can see, we've got a lot of information that we're going to be talking about at this hearing, or I should say at the seminar that we're going to be doing. These are the locations. The first one is going to be at the Sapperton Hall in New Westminster next Thursday, April 25th, from 6:30 to 9:30. And the second one will be at the Comfort Suites Hotel in Kelowna, British Columbia on Tuesday, April 30th. We're going to be working at getting some dates in the prairies and various other locations in Canada as well. And hopefully in about 2 to 3 weeks, we're going to have a video available, as well as addition to the package, the book that we have. Our book is called The Criminal Charging Process in Canada, and it contains copies of information forms from every province and territory in Canada. No matter where you live, the form is in there for you to fill out to lay your own criminal charges. It contains sample legal documents that you can use to fit your circumstances. If, for example, JP absolutely refuses to take your charge, say because you're charging a police officer and they tell you to go to the police to lay a charge. The forms are in there to deal with that, and we have done that successfully in the past. We have got superior court orders forcing them to take it. And blank copies of the forms we used that are required to be used are included. In addition, we have about a little over 95-page written book, annotated, describing all the details of everything you need to know to lay criminal charges that we have learned over the last 15 to 20 years. All the case law and authorities, there's about 100 and something, are referenced in there along with the citations. So you can go and look up the cases as well. Don't take our word for it. You can go and look up the case law that we're referring to, or the sections of the criminal code, for example. Everything is in there that you will need to lay a criminal charge in Canada. As it stands right now, it is the only and the best basically annotated version in Canada of the procedure on how to lay criminal charges. Even the legal community does not have a book set aside specifically for this issue. And the benefit that we get is that it's drafted and intended to work from a perspective of you holding the government accountable, as opposed to when lawyers or judges and so on, they write their books, it's always from a perspective of how the government enforces the law on you. We came at it from a unique perspective of saying, no, we're holding you accountable, and we're going to teach people how to do it so that we can hold the governments accountable. So at any time in the future, because this can also be used in a private case if somebody assaults you, for example, you can share this information with others to get them to lay charges. And we want to get more and more people laying charges against government officials in Canada to hold them accountable when the police won't do anything. And for a lot of government offenses, the police are just brain dead. They don't know how to apply the law to charge government officials who have committed criminal offenses. And in many cases, they will tip off the government officials, especially in smaller communities. If the government officials have been charged, they will try and tip off who who you are charging, so that they can maybe destroy evidence. And interestingly, I'll tell you a little story before I finish off here and we take questions. We had a case where a friend of mine charged government officials, 6 of them, and the procedure that is in place and has been for 100 years requires that the accused person is not supposed to be notified they've been charged until or unless a summons or warrant has been issued. Because if nothing happens, if the judge says you have no evidence, then it's just kept under wraps so nobody ever knows about it. And if the judge does issue a summons or warrant, then of course the accused will know at that point. And the primary concern is that you don't want to charge somebody and then have them run out and destroy evidence before you even get heard. And we had a Crown prosecutor violate that law and go and tip off the accused that they had been charged and got information from them that he used to try and oppose a summons being issued, if you can believe that. And the law is clear, they're not allowed to do that. And that case is still before the court dealing with it right now. But ironically, guess what? That Crown prosecutor is now a provincial court judge in British Columbia. Okay? So we're dealing with that at the Court of Appeal level here in BC right now. Excuse me. But it goes to show you how aware you have to be of what the powers and duties that these people have and what the process is involved along the way, so that you can ensure your rights are protected at every step of the way, and these people don't go behind your back and try and play some tricks on you to try and cover up for government officials. So having said that, that's basically all I wanted to share with you tonight, is to give you an overview of what we're going to be talking about at our seminars, and hopefully you can all come down and show up and and say hi and get some information. Hopefully, you'll be able to follow through with it if you're laying your own charges against the government. And right now, I'm prepared. If anybody has any questions, I may need some hands with Mike on how to work this, but we can certainly take any questions if anybody has any right now.
If anybody has a question and has a microphone, you can click on the little hand icon and we'll know that you want to do that. And we'll open your mic and you can talk to Dave. I've had a couple questions come in that I've answered, the ones that I could handle. Did you say exactly how people could get a copy of the book if they're not coming to your workshop?
Yeah, our address is on the screen right now, and the book itself is $75 and it's $15 for shipping. And you can just, normally we recommend cash because we don't deal with the banks, our group clear. And you can just wrap it up, and we haven't never really had any problems with it. And you can just send it to this address that's on your screen right now. P.O. Box 21113, Cherry Lane Mall, Penticton, BC.
All right, and there was a question with regards to what was your success ratio for convictions over the years?
The charges that I have laid, I have not got a conviction myself. I've only actually laid about, I think, 4 charges. 2 were in Manitoba when that policy was still in effect, that they weren't taking them for a while. We had a friend of mine here. The Crown opposed him and lost, and it did go to trial. And the judge commented in his decision, he had 3 witnesses, and 2 of the witnesses did not show up. And instead of adjourning to get a warrant for them to appear, he decided to proceed anyway. And the judge said that he had, he had a little bit of doubt because there was only 1 witness. If his other 2 witnesses had appeared, he would have entered a conviction against the police officer for assault. And that goes to show you how important it is to make sure that you get all your evidence at trial when you get to trial. If you have witnesses and they don't show up, they could cost you your case. And we got a couple cases right now that are still before the courts. There have been people that have done private prosecution successfully, and I have read cases on them. I have not been successful myself, which doesn't bother me in any way. I know the corruption that these people have gone. Most of my charges have been stayed by the Crown before it ever got to trial.
And I remember hearing about that years ago when you were taking some stuff to trial and they stayed it, but you mentioned in this overview that that process has changed where they can't stay them anymore?
Yeah, they cannot stay it anymore before your process hearing. Once a judge says there's enough evidence to take it to trial, and I'm going to issue a summons or warrant, the Crown can still stay it, but the obligation becomes higher, and they have to basically give reasons and say why they're going to try and stay your charges now. Before, they would just walk in and stay it, and that was the end of it. But yes, things have changed a little bit now to our benefit.
Okay, and there's a question here. I've been told that Ontario does not have a sheriff. We have court enforcement officers used mainly for evicting tenants. Police support the CEO. What can we do in Ontario?
Well, the sheriffs themselves don't really play a big part in the process. When you're laying charges, the only one that's involved is a justice of the peace when you go to swear your charge in, and yourself. After that, it goes before a judge who will hear your evidence. The only time a peace officer is going to be required is if a judge issues a summons or warrant. If there's no sheriffs in Ontario, they will get a court official or a police officer to go and serve the summons or to enforce the warrant on whatever is served. So it's not terribly important. It's not terribly important as to who is going to do that, other than to know that the court system does have people in place that will do it.
Okay, and the seminar is a one-time or is there multiple? It's just a 3-hour, correct?
That's correct. It's just a 3-hour presentation on everything we have here, and of course we'll be taking any questions that are at the seminar as well.
Do you have a DVD available of the seminar?
At this point, no. Probably in about 3 weeks we will have a DVD available. We're going to be making one. I've had request to video the seminar at Sapperton Hall, for example, I'm not a big fan of doing live videos simply because my experience has shown they generally come off very unprofessional. Um,
Which is
you
all
can
the
get
more reason to take me up on my offer about doing it via webinar.
which is an option.
Yes. All right.
The object is to keep it in a controlled circumstance, however, so people get a professionally done presentation. Um, as I said, my experience in the past, you can get people in the gallery that could disrupt the presentation for whatever reason. You can get problems with your equipment and so on, and it just doesn't look very professional when you want to get it out
Right.
on
Well,
DVD. So
I
we,
control the
we,
mute
we
button
try to
here,
do
so we can keep the gallery quiet. Can this method apply to the U.S.? Probably not. They have
the
different procedures and stuff. Like some of the concepts I'm sure would be the same, but procedurally it's
yeah, the concept is the same. You can lay charges in the states, but in the states is different than Canada, primarily because in Canada the criminal law is done by the federal government. In the states, each state creates its own criminal code. They don't have one federal criminal code in the U.S. So as a result, every state will have its own different procedures for you to lay your criminal charges. And you would have to find out the procedures in the states to do it because their system is fundamentally, procedurally, is fundamentally different than ours.
okay. And how would we lay charges? The orders are issued by the landlord and tenant board or banks. I think that goes back to the Ontario does not have a sheriff issue. Um, it's the same thing in Ontario as in BC, where you go down to the court and lay the information at the registry, don't you?
Well, I'm unclear if they're referring to laying charges against people under provincial statutes, which is a radically different concept. Um, Provincial statutes, for the most part, if not entirely, are regulatory because the provinces cannot pass criminal law. And you would have to look to each statute to see if there's a procedure in that statute provincially for you to lay a charge, and and then how to go and follow it. And there could be, I mean, every province could have 100 statutes or more with offenses in it. In BC, for example, you have the Offence Act, which generally applies to all offenses created by other statutes. Most provinces probably have something similar. And it would probably, in the Offence Act, state the form to use when you want to lay a charge under, say, a Landlord and Tenant Act or some other statute in the province. And in Ontario, you probably have a similar statute which would set forth a form to use for laying charges against somebody for provincial offenses. And you would simply have to look into that statute. I don't know what they would be in every province. Um, I couldn't tell you. In Ontario, the Courts of Justice Act may have some applicability, um, but in all likelihood, there's probably a different statute you would have to look at.
Okay. And another question related to an earlier one: isn't a sheriff required in the province?
No,
Ontario.
some provinces have sheriffs. Others, like Ontario, have an OPP or they have bailiffs or whoever. And as I said, you don't need a peace officer or a sheriff to lay a criminal charge. The only thing the peace officer is there to do is to serve the document on the
And,
offender, and that could be anybody. It doesn't matter who
and
says it.
sheriffs play a very different role in Canada than they do in the U.S. as well.
Oh,
Yeah.
much different, much
Uh,
much different, and their powers, and duties are
right.
different.
And how much is the seminar that you're doing?
The seminar is $60 for the evening, and one point I should point out as well: the process for laying criminal charges is free when you go and lay your criminal charges. The court does not charge you anything for doing it, and that's important for a lot of people to know that it's a free process.
All right. And do you have seminar dates for Ontario? I think you said not yet, right?
No, we don't have any as of yet, and I suspect within about 2 to 3 weeks we'll have dates set across the rest of the country for us to do as well. We're just getting started right now, and I find this every year. Just as we get started, the May long weekend seems to creep in and screw form our how we're going to set our dates up and everything, and it has again this year. But we'll be setting them out in the prairies. We'll be getting some done shortly, and we'll be working some out in Ontario as well. So within a couple, 2 to 3 weeks, we'll have dates set up across Canada as well.
Okay. Do you have any experience charging mortgage company executives for the massive mortgage fraud being perpetuated?
I don't. The only thing I can say is that it can be done, and all you need to make sure to get the fear into them that we want to get is that you have enough evidence at your process hearing to support what you're saying. And by evidence, I don't mean legal arguments. I don't mean walking in and saying the statute is interpreted this way, what they're doing is wrong. I mean, you actually need documents or evidence to show, hey, this guy did something wrong. And we'll talk about the difference between evidence and argument at the seminar as well.
Okay. And you don't take PayPal?
No.
Okay. No dates for Edmonton. They're all being set still. What support resources are available when in the process of laying charges, including your information?
If people have come to the seminar or have purchased a copy of the book, we take questions and we'll answer all your questions no matter what. You can just send us an email and we will answer all your questions right through the entire process until you get to your hearing. And there's myself and others. We'll be glad to assist you if you have questions on how to fill out the forms. If you've got a criminal charge you want to lay and you're not sure how to word the charge, if you've been to the seminar or have picked up a copy of the book, we'll be glad to help you do that all the way through the process.
Okay. I've got some appreciations and thank yous here and good presentations and so on. So some good feedback. And like I said at the beginning, if you missed part of the presentation or you know somebody who missed this particular webinar, you'll be able to find it under the training tab under guest webinars. And Dave's got a link down there. So this is a particular page. The webinar will be posted on here as soon as it's edited and processed, which should be sometime late tomorrow. Any more questions, feel free to email Dave. And with regards to your comment at the beginning, I did a course, I guess a little over a year ago, called Your Complaint Is Their Restraint, which you mentioned at the beginning. And it's, the fundamental principle, as you addressed, is that criminal activity is going on all the time by the politicians and the police and corporations and so on. And for so long we have felt we couldn't do anything about it and had no power to do anything about it. And so the first step really is an understanding that not only do you have the power, not only is it your right, but it's your duty to actually report these things and lay charges against these people. Otherwise you effectively consent to it being done to you and continuing to be done to other people. So I'm grateful that you've done this work, and I've known you for years, and all the stuff that you do for everybody across the country is just phenomenal. So thank you for your work and your continued efforts, and I hope that everybody will take this to heart, that you do have the power. We, the citizens, are the power that controls the government and the police forces, but only if we complain, and that complaint is through a legal process. Whether it's civil complaint or a constitutional complaint or a criminal complaint, those are all avenues to you, and we need to understand that, like I said, not only can we do it, we have to do it if we want anything to change. So,
absolutely.
Okay. And if anybody wants access, the website here has a lot of free information. If you want some of the members only information, you need to become a member. You can log in or become a member here. It's free. There's also some paid access information on the website. Oh, one last thing I wanted to mention. Just like Dave is a guest webinar presenter today, I've had some other people in the past. If you are interested or you know somebody who's a quality teacher, has some real experience and some real information to share, and they want a platform to get it out, one of my goals here is to make the webinar system available for people. The webinar system holds up to 1,000 people online at one time, and we need to get the information out. We need to get the training out. We need to let people know what they can do and how to do it. And so that's one of the things I'm trying to do, is support good educators to do that. So thank you very much for coming on, Dave, and sharing this. And anything else you want to add before we close it down?
No, I'm grateful for everybody to come, and again, I'm grateful for allowing us to have this on tonight, Michael. I'm very, very
My
grateful. Thank you
pleasure.
for your
My
time.
pleasure. Everybody, thank you very much for attending. Have a great week. Watch the website. I've got a webinar coming up next week. There's always something going on. There's more and more court activity these days as well. So watch for updates on that as well. So have a great week, everybody. Thanks a lot, Dave, and take care.
Thank you.